Okay. All right, so I'll ask Thomas to bring up my PowerPoint. And hopefully you can all see this. I'm going to give a brief introduction to CITES. Much appreciate the Ofwat CITES reps pulling this webinar together today. Some of what I say may be old school to you, and for some of you may be new. I just thought it would help set the tone to have some introduction to what CITES is and what the Fish and Wildlife Service role in CITES is. So next slide. So basically, we are structured under the treaty. It basically requires parties that are signatory to the treaty to create both a management authority and a scientific authority. And those offices are independent of each other. However, in Fish and Wildlife, we report to the same assistant director. Right now, our acting assistant director is Bridget Fahey. Prior to that, our AD was Brian Arroyo, who led us at the COP, and many of you probably knew Brian. That position is currently vacant, and we have actings, and hopefully we'll have a permanent AD soon. So the scientific authority's role under the treaty is that we provide technical and scientific advice for implementing CITES. Basically, that means that we help draft the proposals that the U.S. would submit to CITES and evaluate other parties' proposals to determine the USG position. We also advise DMA on the issuance of permits. The scientific authority has the responsibility of making what's known as a non-detriment finding, and we'll go into that in one of the further PowerPoints. But basically, the purpose of that is to ensure that the export of the specimens is not detrimental to the survival of the species in the wild. Essentially, a non-detriment finding relates to, for Appendix 2 species, that we have found that export to be biologically sustainable. And so we're structured. We have two branches. Thomas is in charge of the conservation science policy branch, which prepares us for the CITES meetings, including the COP. Whereas Eleanor, she'll be speaking to you, is in charge of the branch of consultation and monitoring, which essentially is where the branch responsible for making the non-detriment findings. And the biologists basically work for both branches. And then we have a division of management authority, which has a branch of permits, which you met Mary is manager of that. Wildlife Trade and Conservation branch, which does policy. And the Combating Wildlife, that has now moved to our division of international conservation. But the Wildlife Trade and Conservation branch essentially is responsible for the standing committee, CITES Standing Committee, and also doing everything for the implementations of the listing. So it's joint work, and the branch of permits, you'll have a presentation on this, is responsible for issuance of the permits and making the legal acquisition findings for the export of the specimens. Next slide. So what is CITES? As Deb said, it's known as the Convention on the International Trade in Endangered Species of Wild Fauna and Flora. That said, it also regulates the trade in captive bred and artificially propagated plants. So captive bred animals and artificially propagated plants are also covered under CITES. It's an international treaty that was entered into force 1975. The U.S. was one of the driving forces in the creation of CITES in the 1973. We are celebrating 50 years of CITES this year since it was drafted, and so it's a big milestone. It has stood the test of time. Currently, there's 183 countries and the EU that are parties to CITES, i.e. the parties are responsible for implementing CITES and making the decisions. Almost every country in the world that has international wildlife trade is now a signatory to CITES, with the exception of some Pacific island nations. So the purpose of CITES is to regulate the international trade in wild fauna and flora to ensure that it is legal and biologically sustainable. Next slide. The Endangered Species Act of 1973 is essentially our authorizing legislation that establishes the Secretary of Interior, who designated the authority created the Management and Scientific Authority and gave that authority to the Fish and Wildlife Service. So that's the laws that regulate us and how we implement CITES. Next slide. And our regulations are found in part 23. Thomas, don't do the streaming, just hit this one. But some common misconceptions about CITES is that CITES deals with all aspects of wildlife conservation. That's a misconception. CITES basically only deals with species that are in international trade, that are in its appendices. And we'll talk about the appendices in a few minutes. Another misconception, CITES aims to promote all wildlife trade, or CITES aims to ban all wildlife trade. CITES is not a ban on wildlife trade. It aims to regulate the international trade. Next slide. CITES regulates domestic trade. No, CITES does not regulate domestic trade. It only addresses international trade, i.e. the export of CITES listed species. The other CITES appendices, this is one that the public has a misconception about, or some of the non-government organizations. The CITES appendices are a listing of the world's endangered species. No, basically they only include species in its appendices that are or may be affected by international trade. Essentially, CITES was created to address the trade in international wildlife. So it is not a mere copy of the IUCN Red List. Okay, and how does CITES work? CITES basically regulates export, re-export, and import and entry of the sea of live and dead animals and plants and their parts and derivatives listed in the appendices. And it does this through a permitting issuing system. And so permits can only be issued if certain conditions are met, i.e. the U.S. has made a non-detriment finding and a legal acquisition finding for that export. And when those specimens leave the U.S., that permit is presented to our law enforcement, our fish and wildlife inspectors, who have the responsibility of clearing shipments, both entering and leaving the United States. And also, if you're trading with a CITES party, that permit needs to go to the other CITES party. Okay, next. So, as I said, permits can only be issued when these two findings, which are required by the treaty, are made, and one of them is a legal acquisition finding, and we'll talk more about that in a presentation to follow. And the scientific authority makes a non-detriment findings. So, essentially that we've talked about that. Eleanor will talk about the kind of information that we use to make a non-detriment finding, and this is where we really need to work with you and complement your efforts and your information on the species. Next slide. So why is this all relevant to our regions and other state wildlife agencies? Well, we consider in Fish and Wildlife that if a species is in trade or can be threatened by international trade, then CITES is an appropriate conservation tool to help assist the management and conservation efforts for such a species. And so we look at, in the scientific authority, native species that occur in the 50 US states or our territories of the Commonwealth of Puerto Rico, when we look at species that the US may consider proposing to be added to the appendices. We also look at foreign species where the U.S. is a major importer or exporter. And so CITES is this tool, as we keep saying, that basically hopefully can address trade specimens that are threatened by trade. It can also complement efforts under the ESA where there's a concern about trade. A good example that comes to mind is paddlefish were listed in the CITES appendices in 1992 because the Fish and Wildlife Service had received a petition to consider them under the ESA. And in determining that finding for the ESA, it was found that trade, if not regulated, could propose a threat to paddlefish. And therefore, we took a proposal to CITES and included paddlefish in Appendix 2, and thereby hopefully did not have to deal with paddlefish as an ESA listed species and addressing the real threat that we at the time, which was overharvest for caviar trade. Okay, next slide. So how does CITES work? As I said, we put species at a COP. There's 3 appendices to CITES, Appendix 1, Appendix 2, and Appendix 3. Appendix 1 is probably the one that gets all the media attention, where commercial trade is generally prohibited unless there's special circumstances. And so these are what you think of: tigers, rhinos, except for the annotated populations, are generally in Appendix 1. Most of the elephant populations are in Appendix 1. Appendix 2, though, is the meat of CITES. This is where basically you regulate the trade. This is where most of the animals in CITES and plants are, in fact, in Appendix 2. And the thought is, if you regulate the trade in Appendix 2 species and make robust legal acquisition and non-detriment findings, you will basically prevent that species from meeting the criteria in Appendix 1 if trade is really the threat. Of course, threats to species are interrelated, but CITES' purpose is to try to at least address international trade. So most of us who work in CITES spend almost all our time on Appendix 2 species rather than Appendix 1, but Appendix 1 species get the attention. To add a species to CITES Appendix 1 or Appendix 2, and we've worked with the AFWA representatives on this in the past, is basically that is a decision of the CITES parties when they meet at a conference of the parties every 2 or 3 years. As Deb said, we recently had the last CITES conference was in November 2022. And at that conference, basically parties made decisions to what species should be included, added to Appendix 1 or transferred from Appendix 1 to Appendix 2. Appendix 3 is not a decision of the COP. Essentially, that there's a resolution on how you add species to Appendix 3, but essentially it can be thought of as a way a national authority, a party, can put species in Appendix 3 if they're trying to regulate and complement their national controls on that species. So that's one that does not need a decision of the parties. For the United States, if we add a species to Appendix 3, we have to go forward with a proposed Federal Register notice that would propose that and have public comment period. And at the end of that evaluation, if it's positive, we then add it to Appendix 3. All of the movement of any species in CITES Appendix 1, Appendix 2, and Appendix 3 does require a CITES permit for export from the US. Next slide. So now we go to Panama, and essentially at this COP, the US basically submitted 14 proposals to add species to Appendix 2 or transfer some species from Appendix 1 to Appendix 2. Our leadership, this administration at this COP really focused on the trade in native species, which is what brings us together today in this webinar, is that we brought proposals forward to look at trade in US herp specimens. Next slide. As Deb said, that basically when proposals are adopted, they're generally effective 90 days from the end of a COP. So for the proposals that were adopted at this COP, unless it's specified, and the implementation date was February 23, 2023. For some of the timber species and some of the shark species, we did establish a delayed implementation, so they'll have a different effective date, but I won't go into those because today our focus is on the reptiles, and the decisions made on the reptile proposals were all effective February 23rd. Next slide. So what proposals, what are the reptiles we're going to talk about today, and what brings us all together? We had one proposal that came out of a CITES process called the periodic review, and we basically moved the Puerto Rican boa from Appendix 1 to Appendix 2 because it no longer met the criteria for inclusion in Appendix 1. That's not to be confused with current action for the Puerto Rican boa under the ESA. I think we have a proposed rule out that would remove it from ESA, but it's the action taken at CITES is independent of that ESA action. Desert horned lizards, we brought a proposal forward, the US, to include one species in Appendix 2. However, Mexico brought a proposal forward to include all horned lizards, all Phyrosoma species in Appendix 2. The parties, according to the rules of procedure, we discussed the Mexican proposal and our proposal. The Mexican proposal was supported by consensus by the parties, and so we didn't do an individual decision on the desert horned lizard. All horned lizards are now included in Appendix 2, including the US species and the Mexican species. The timber rattlesnake, we also took a proposal to include it in Appendix 2, and hearing the discussion and some of the concerns raised that trade was not a factor for this species, we withdrew that proposal at the COP after the debate. We took a proposal for big-headed map turtles to transfer the species from Appendix 3 to Appendix 2. And that proposal was adopted by consensus. They are now in Appendix 2, and any export of these map turtles requires not only a legal acquisition finding, which is what you needed only for Appendix 3, but now requires a non-detriment finding as well. And that'll be true of some of the other ones we transferred to Appendix 2. Soft-shell turtles, all the Apollon species that were not in the CITES appendices, there was a subspecies in Appendix 1 from Mexico. We transferred the genus. All the species in this genus are now transferred from Appendix 3 to Appendix 2. Next slide. And that was adopted by consensus. The US turtle proposal that came up first in the discussion at the COP was a proposal to include alligator snapping turtles and common snapping turtles, transfer them from Appendix 3 to Appendix 2. This one went to a vote. And essentially, you need 2/3 of the parties voting that are accredited to accept a proposal, and it received the 2/3 vote. Most of the opposition came from the European Union, which essentially only supported putting alligator snappers in Appendix 2. We also had a proposal to include musk turtles in Appendix 2, and that proposal was adopted by consensus. And then there was a proposal that we co-sponsored with Mexico to include all 20 species in the genus Cynosterna in Appendix 2 and 2 species in Appendix 1. That one was also adopted by consensus. And so essentially the US, in bringing these turtle proposals forward, was concerned about the biological sustainability of the trade in this species, and leadership made the decision to move forward with CITES as a mechanism to regulate the trade in these species. To do that, we really need to work with the states, and I hope we can approach this all in a collaborative manner and basically now work with our stakeholders to make these listings effective. We've learned a lot from when we included diamondback terrapins in CITES Appendix 2 that I think we will follow that model in DSA in trying to work on these species. Next slide. And so basically, this is what brings us today. This is sort of my thoughts I share on effective implementation of CITES reptile listings will require, and this is based, I became DSA chief in 2007, and so I guess these are my observations on what I think it's going to take for the US to do this listing right, and definitely going to need to work closely in collaboration with you, in communication with the states and AFWA in doing this, and information sharing is hopefully today the first step of how we go about doing that. And we need in DSA and DMA a better understanding of the current state management and regulations for these species. I'm happy to report that we found funding to basically update the IUCN Red Data List assessments for these species that we put in Appendix 2 now. So we are in the process of going forward with a contract with IUCN Tortoise and Turtle Specialist Group to update those IUCN Red Data List assessments. And the other thing that we all are involved in is working on outreach to the impacted stakeholders, our turtle farmers or turtle harvesters, and people who collect reptiles and other parties. And so, for example, we recently, Thomas authored an article. There were many other reptile species added to CITES Appendix 2, turtles from Latin America, Asia. And so there's basically an article in Reptiles magazine, and the link is provided here. And I assume Deb will share these PowerPoints with everyone. Otherwise, we can, we'll make sure we give them to Deb so that they can be circulated. But this gives you a link, and if you're interested, it's a good outreach tool to provide people as to, what new reptiles were added to the CITES appendices. Last slide. And I guess I go back to, what is the purpose of all of this? Again, reminded that CITES is to ensure that international trade in wild fauna and flora is legal and biologically sustainable. And that's it. And Deb, if you want to handle questions, do that. And then we have 2 more presentations on legal, one on legal acquisition and one on non-detriment findings. So any questions on those, we could probably, hopefully we'll answer in those PowerPoints, but we can defer those questions, Deb, to that particular session, so we stay on time.
Hey, Rose, I just wanted to hop in, and the acting branch chief for wildlife trade and conservation is here, and I just wanted her to be able to introduce herself to the group. Dara.
Hi, everyone. It's nice to be on the call. And I'm Dara, as Naima had said, and I'm the acting branch manager for our wildlife trade and conservation branch for a few weeks. And normally I serve as a CITES policy specialist and work with American alligators and our CITES export program. Thank you.
Thanks, Dara. Thanks, Naomi and Rose. That was great. A really nice introduction to CITES and where we are. I see the link in the chat, and certainly, Rose, if you guys share your PowerPoints, I will be sending a follow-up email to all the attendees with PowerPoints, with a link to the magazine, any other resources that we think would be good, your contact, any of the state, the Fish and Wildlife contact information. So we can definitely take care of that. Thomas Floyd from Georgia DNR was asking about the Swanee alligator snapping turtle.
Yep. Okay, so let me handle that one. And if I get it wrong, Thomas, or I miss something, please jump in. Although Thomas doesn't have a mic, look at one of the other biologists. But CITES follows its nomenclature. We have a standard reference for reptiles that we have adopted. And essentially, we did not split the common snapper into 2 species. So when we use the CITES terminology of macrocheles, we are including the swinensis under that one in Appendix 2. I know this is different from discussion under the ESA, but essentially we are required to follow CITES nomenclature, and so we basically left this either species or subspecies with the common snapper. And Thomas, if you have a mic, did I get it right? I see you nodding your head.
Shaking his head.
Okay.
Great.
It is covered. It is in Appendix 2.
Thank you, Rose. Gordon Batchelor from the Northeast Association of Fish and Wildlife Agencies was asking if you had any initial ideas on how Fish and Wildlife Service will handle captive bred snapping turtles.
Yep, we recognize that there are a number of farms for captive bred snapping turtles. We will, I believe our presentation on legal acquisition will talk about what we're going to be asking. There are a number of current farms that are registered with us, have master files. We will need to ask for additional information so that we can make a non-detriment finding and look at legal acquisition in terms of resolution comp 10.16, but on captive breeding. But more importantly, Gordon, we will be working with the states. I mean, my understanding is that some of the states have regulations in place that register these farms, for example, Florida for soft shell turtles, and we will be looking at you you know, to how you regulate these farms and your assurances that they are in fact captive bred. We may make some visits to farms we did this with Diamondback Terrapin to see if they, you know, what their production capability is, so that we can sort of basically make a non-detriment finding for that facility, that they can produce so many in captivity, and any numbers above that we would then, as we learned from Diamondback Terrapin, that was a good approach, because in looking at a facility in Maryland, we certified them for a certain number of turtles and they exceeded that capacity, and it turned out that exposed a loophole in the state of New Jersey's law, where they were collecting gravid females during the crabbing season, which was allowed, but not, anyone never thought they were collecting them for commercial purposes. They thought they were collecting them for bait for crabs. So New Jersey, as a result of that, amended their regulations. And it's a good example of how we worked with AFWA. We worked with Buddy Baker on that one to basically work with both the state of Maryland and New Jersey. So that's my initial ideas. Welcome to any brainstorming that we might have. We might do a separate meeting with those of you who have turtle farms, so that we can, you know, really brainstorm on how we might approach this and ask the right questions and not be overly burdensome. You know, and initially, you know, right now we know there's a transition from 3 to 2. You know, non-detriment findings evolve through time. Buddy knows that well. And so we basically will look at this year and then improve things the next year and work with you guys to make this all biologically sustainable. And then I see the question from Buddy on the FWS contract to update the IUCN species. Unfortunately, I only have X amount of dollars. And so right now the contract is for the new species we've listed, with the exception of snapping turtles, because at the COP, we heard from the Europeans and the Latin American countries that there is concern about the macroclimies outside of the United States, and we don't have good status information. So we will basically have asked IUCN to update all the snapping turtles, but we did not, the contract does not include us looking at river cooters or some of the other native turtle species in the US. It's something that I would like to see us do in the future, because we well know when we regulate the trade in some species, it may cause people to shift to trade in another species. And that's why we're looking at the whole genus of snapping turtles. But I didn't have enough money to do the rest of the native US turtles, but it is on my wish list as we get money, if we can think of a creative way to include it in some of the work we're doing on the American Rescue Plan Act. We have some funding for that, so maybe there's some way of getting some of that information there. I'll have to be creative, but yes, Buddy, it's something I think about, and $50,000 only got me so far, which is less than what some IUCN assessments cost for one species. So I think we're in a good place to get what we needed.
Thanks, and I just wanted to,
yeah.
I'm sorry. I just wanted to back up and back to the snapping turtle issue and just give anyone on my team from the branch of permits an opportunity to weigh in on that question. I don't want to be redundant to their presentation, but I didn't, if anyone wants to hop in.
Hey, Naima. I think the presentation will cover it, but if you have any questions after the presentation, feel free to ask then.
Thanks, Heather.
Great, thanks, Heather. Anything else for Rose? And also, if you come up with any questions that, you know, might even be for Rose later, please continue to put those in the chat, because we'll have more time at the end of the next set of presentations. Okay, I don't see any more hands or any more questions. So Rose, I'm not sure who's next, but they can take it away.
I think it's Eleanor for non-detriment findings. Oh, no, legal acquisition findings, Heather, sorry.
All right, perfect.
Thanks, Rose. All right, so just to introduce myself again, my name is Heather Harpham. I am a permits biologist in the Division of Management Authority. And like Rose had said earlier, we are looking at, you know, splitting this in legal acquisition findings and non-detriment findings. And the Division of Management Authority's goal with this is to work solely on the legal acquisition findings and then work with DSA thereafter. So we work with a lot of turtle farmers and folks who work and harvest with native species that were recently listed. This is going to be a big focus on the Appendix 2 listings, but we're happy to talk about any other questions that might come after this presentation. Go ahead, Thomas, you can move with it. All right. And then the basic CITES, the permit criteria for legal acquisition in our Code of Federal Regulations states that legal acquisition is whether the specimen and its parental stock were obtained in accordance with the provisions of national laws, and that those national laws include state laws. So I just wanted to state like that is important that for us to collaborate and work together because that does include all local, state, federal, tribal, and foreign laws that must be met in order to meet that legal acquisition finding. And then also if it was previously traded, that it was traded internationally in accordance with the provisions of CITES. And that's just making sure that they have all of their documents if they were previously traded outside of the United States, but we're going to be focusing on that first half when we're talking about native species that are either produced or harvested in the United States and then commercially or non-commercially exported thereafter. So legal acquisition finding must be made by the Fish and Wildlife Service before issuing any permits or re-export certificates under CITES. Okay, go ahead. So what should a turtle farm or a facility provide to establish legal acquisition? They're going to submit to our office, since the Division of Management Authority works directly with the applicant, a complete and current application form. We have one set up specifically to register facilities for the export or the commercial export of native species that are listed in all the appendices or Appendix 2 and 3. Application form 3-200-75 is the application that they would use to export native species. And at this time, we are working on a new application form that should be up by August 2023. But until that time, we do have some additional questions that we will be asking them because a lot of these species went from Appendix 3 uplisted to Appendix 2. So there is an annex form now that we're going to be asking additional questions to get a better understanding of their current methods and in order to find non-detriment finding. A processing fee is currently required it's currently $50 for U.S. native species facilities, and then any supporting documentation, which we'll get into. All right, thanks. All right, so we ask our applicants to provide us with information on the legal acquisition of both their current stock, what's actually being requested for export, whether that be hatchlings or something that was harvested from the wild that they're looking to export from the United States in their facility. And then we also ask them questions about the parental stock if they were bred in captivity. So the information that we request for their current stock and what they're actually looking to export is going to be, labeled photos of their facilities. We want to see what they look like, the ponds, incubation rooms, storage, packing, breeder stock, their eggs. We want to be able to see those and have a good description of what's going on. And then I also wanted to note the disqualification factors. If any applicant has been assessed a civil penalty, they have to let us know about that and provide us with any documentation that's related to that charge. That doesn't necessarily disqualify them, but it is something that we have to look into before we start assessing whether they can be issued a permit or not. And then they also have to let us know the type and size of construction of the shipping containers, since they have to comply under IATA, the International Air Transport Association, any arrangements for watering or caring for that shipment before they are issued. All right. Additionally, for their current stock and facility, we'd be looking at the chain of custody of specimens being exported. If this was harvested, or if it was sent from facility A to facility B before it's being exported. We want to see those transfer documents, any report forms that are required by those states, invoices and receipts, or at least a signed statement from the seller or donor of those specimens before we issue a permit and find a positive legal acquisition finding. We also want to make sure that both of those parties, whether the person who's exporting is the breeder or the harvester of that specimen, is the only one involved, or if there's somebody else involved who is going to be sending them specimens. We want to make sure that everyone is properly licensed. So we want to make sure that if there is more than one license necessary for possession, propagation, sale, transfer or export to and from a state, we need to see a copy of all of those authorizations. And sometimes in some states, that may be an all-in-one license. In other states, there may be a separate license for transport or for sale or for propagation. So it's very important that we all work together to understand and know what is necessary for each one of those activities between the states and within the states. And then if a license isn't necessary for one of those activities, the applicant needs to be able to let us know that and provide confirmation from the state that that's not a requirement. All right, thanks, Thomas. And we're also going to look for information required for parental stock. This is more focused on our turtle farms who are doing captive breeding at their facilities. So in addition to any legal propagation and sale of their current stock, we have to show that all of their founder stock was legally acquired. And I know that a lot of turtle farmers collected and harvested a couple of decades ago sometimes, but it's important for us to know at that time whether that was a legal harvest or not. Was the purpose legally to harvest legal? So is any subsequent commercial use authorized within the state, which is important for us to note, legal method of harvest and gear used to harvest, the location of the harvest, which may be which waters they're in and the counties that they're in so that we can look at any local regulations, and then any necessary state licenses or permits obtained at the time of harvest. So we're looking to make sure that that facility is registered and licensed and everything within the state at the time they're exporting and requesting this, and at the time that the specimens were harvested, whether that be the parental stock or if they are harvesting to export wild. So any historic regulations are very important to us to determine legal acquisition, especially when it comes to determining legal acquisition for founder stock. And again, if the license isn't necessary at the time of harvest, we are going to require that they get confirmation from the state or are able to show us a regulation showing it wasn't required at the time. If the applicant themselves was not the collector, we're going to look at chain of custody documentation of the original founder stock. If somebody, if facility A had harvested back in 2006 and they're sending that from one state to another to the applicant who is not the collector, we still need to see that chain of custody being sent between facility A and B, as well as all of the information described in the previous slide if the applicant were the collector. So we need to see all the licenses, the purpose, the location, the method, and the gear used from the person who had made that original collection of the founder stock used to establish the facility that is requesting to export. Okay. I'm good at the next slide. Thanks. One question that I know that we've started getting quite a bit is whether brokers can apply. So we have what is called master files, and I'd say this is most frequently what's being used to do exports. Master files are a way that we kind of streamline our process. So if there's there's many hundreds of hatchlings that they're looking to commercially export from their facility. Instead of applying for each export they do, they can request what's called a master file, which essentially pre-authorizes up to a certain number that's sustainable from their facility. And from there, they can request any number of single-use permits, which they can fill in the quantity and fill in the consignee on who receives those hatchlings. We are not going to provide master files to brokers, just to try to prevent the loophole of laundering through one person. However, brokers may apply in one of two scenarios. They can apply for a single-use permit for a very specific quantity and specimen so that we can look into make sure that exact quantity is sustainable, and when we can provide full traceability and legal acquisition requirements from the breeder. And brokers may also apply on behalf of an applicant. And that would work with a master file so long as the breeder actually is the applicant and the master file is being requested legally in the facility's name. Actually, I just wanted to throw out this slide as additional information to consider in addition to the Division of Management Authority's legal acquisition findings, that the permittee also has to comply with the Office of Law Enforcement requirements for commercial shipments. If this is commercial, that permittee will need an import-export license with the U.S. Fish and Wildlife Services Office of Law Enforcement, and the permittees will have to make sure that all of their shipments are inspected with the Office of Law Enforcement at a service-designated wildlife port. We also want to make sure that our permittees know that they must also comply with all of the foreign country requirements and regulations, including any additional permitting or inspection requirements in the foreign country, because other countries may have stricter domestic measures. All right, and I just wanted to be able to share some helpful links and resources. We have our legal acquisition regulations that are available in 50 CFR 2360, the application form in question, the Species Plus, which shows the species listings and CITES, our eDex website, which is the electronic declarations for when they export, and then a list of contacts and addresses for the designated wildlife ports. All right, thank you so much. If anyone has any questions, I know there's a lot of nuance in this. I am happy to answer those. And I also have Eleanor here, who is another one of the wildlife biologists on the team, who works very frequently with these turtle farms, that may be able to answer your questions as well. Thank you.
Thanks, Heather. That was excellent. Really appreciate that information. We do have a few questions in the chat. A basic question, I guess, from John Cart is, if CITES is only applicable to international trade, does it come into play, for example, if a CITES Appendix 2 species is illegally collected in the US and sold within the US with no attempt to move it out of the US? Rose, you have your hand up. Do you want to take that one?
I'll try it, and then if Naima and others, I guess we should have had law enforcement on this, but basically you're right, CITES, we only look at export of specimens, but in doing so, we sometimes have information. One of the things we do is we go back, we did this with box turtles, we go back to the state to see, as Heather said, if the specimens were legally collected. And what we've learned is that basically some states allow possession for personal consumption, but not commercialization of the species, in which case we've denied those exports in most circumstances. And that's why it's so important for us to understand your laws. But if that specimen is illegally collected and it's not going out for export, it's unlikely to come to our attention. It's probably come to your law enforcement's attention or our law enforcement people's attention, in which case, you know, there are other laws that come into play and would be applicable to that situation, and that's why communication between us all is needed. But as a general rule, CITES does not regulate, it regulates exports or imports into the US. It does not come into play with, you know, say it's sold in the US and it was illegally collected. I guess we're talking probably about Blanding's turtle and spotted turtles, some of the recent law enforcement seizures that have happened. And again, that has happened. Law enforcement has worked on those with the states, but it is not a CITES violation per se. It defaults to state law, ESA, and other laws that protect that species. Naima, Thomas, anything anybody else wants to add on that question?
No, I think you captured it pretty well. That CITES is just one element, and we implement it through the Endangered Species Act, but there are elements in the Endangered Species Act that deals with interstate commerce, and there's a whole other suite of prohibitions, as well as the Lacey Act, which is one of the oldest wildlife laws in the books that deals with, you know, unlawful movement of wildlife across, you know, jurisdictional boundaries. And so that would more be for our enforcement folks or your enforcement folks. If it's interstate, then definitely our Office of Law Enforcement would be sort of taking that. But here in the International Affairs Program, under the umbrella of CITES, it is for import and export, and then maybe like use after import, but that's for foreign species coming into the United States.
Great.
Mary or Heather or Maris, anything else to add?
All right, thank you both. That was excellent. Heather, I think this one is probably for you from Gordon Batchelor, the Northeast Association. I don't know if you've seen it in the chat, but it's a question about the disqualification factors and what is meant by, quote, relating to the activity for which the application is filed. And then it has a second part there, but
Yeah, for that first part, for the disqualification factors, it actually does go on a little bit further in that paragraph to state some examples of what that might be. It could be violation of the Lacey Act, Migratory Bird Treaty Act, Endangered Species Act, any charges under that, and then related to the activity for which the application is filed. That could very easily be violation of state law or local law. So when we look at legal acquisition finding, if they've been charged in some way. So that would be separate from the actual legal acquisition finding that we do. So we may have a negative legal acquisition finding, but the disqualification factor comes before they even apply. And so that's if they are charged in some way. And Naris, I will let you add on to that if there's anything additional.
No, I think you covered very well, Heather. And if the applicant, for any reason, depending on how they answer the question, then there are certain options, and we will go as we receive each application. And this is a question that is asked in any application form that we process at the office. This is not just related to turtles, but for all the application forms that we process at the branch. Thank you.
Yeah, I'll just add to what Amara says, like these are conditions that are set in our Part 13, our CFRs for what is it called, for permit administration. And so these govern not just international affairs, but these are permits across the service. So migratory bird permits, ES permits, these are the disqualifying factors. And so normally it deals with a conviction, a felony violation, revocation of permits for a particular reason, but those are in our regulations, and I can pop them in the chat if you guys would like.
that'd be great. Thank you. Naomi. And the second one, I guess it was sort of more of a question, Heather. Have you ever used or considered using the potential Interstate Wildlife Violators Compact as a tool to identify unlawful activities?
I have not, but I am also not aware of that. But if anyone else wants to chime in, they can. I would like to hear more about that though.
Okay. Thanks. We'll see if any other information comes up with that. And Naima, I see you put the link in the chat, so thank you for that. A question from Scott Buchanan. In the event that a turtle farmer cannot provide adequate documentation to meet a legal acquisition finding, what can they expect next? What will be expected of them in order to come into compliance to ensure they can continue to operate? I don't know if that's a question for Heather or someone else in DMA.
Yes, I would like to say to everyone that once we receive an application based on the information provided by the applicant, if we're unable under CITES to meet the issuance criteria, the permit request will be denied or partially denied, could be both. And we have a process of, once the permit is denied, to go to the reconsideration process, the appeal process. So the applicant will have the opportunity to provide information in order to go through that process to see if they met the requirements. But I think that at this point, that is why it's so important for each of the applicants to comply with the state regulations and be sure that they are, that they have all the permits in place and that they have all the documentation needed and provided before they applied for the permit.
Perfect, thank you. That's very helpful. There's a question. Oh, Rose, do you want to speak to that or something else?
Yeah, I just wanted to add that for the species that were in Appendix 3 previously, which some of the turtles that are farmed were in Appendix 3, that legal acquisition finding was being made on those facilities. So this isn't something new. What we're really trying to get at is the biologically sustainability of that facility, questions that address whether they, if they say they produce 15,000 individuals, whether that in fact is true. That they have that capability. And so, I think that this legal acquisition finding is not something new, but it is a question looking at 10.16 that now comes into play for Appendix 2 species is about the founder stock. And that's why it's so important to have communications with you, with the states, that if they regulate these farms and they know the farm was established in such and such year, that they can help provide some information to us that the applicant may not have available easily, but that you have in your records. So it's a dialogue, Scott, that has to happen between us and the states. We do it for paddlefish, we do it for other species. So this is just the start of that conversation. But some of the people, as Heather said, have had master files before, so I have some of this information. But I know it's an issue we encountered with box turtles in particular, where we have had brokers in some states that gather them all up and from different breeders, and so those questions need to be asked. And when we find out some of the breeders definitely can't produce what the broker says they can. So anyway, something to factor into future consideration. Just wanted to add that for clarity.
Thanks, Rose. Appreciate that. Lindsay Garza from Texas had a question. What is the current time frame for application processing in this case? And I'm not sure if that's the whole application or just the legal acquisition finding, but any estimates on that?
I'll jump in with what I can. I think that really depends on how complete the application is. I would say a lot of the times we get fairly incomplete applications, and so that back and forth process of trying to get additional information does take up more time. But if we are to get a flawless, complete application, which hardly ever happens. You know, for legal acquisition finding, it can take 30 to 60 days. But then the non-detriment findings are fairly new in this process. So, you know, I can let DSA speak to that, but I think that it would take some time, especially this year, knowing that a lot of these species are going from Appendix 3 to Appendix 2, that there's a whole other process that's being done right now. So that may take a little bit of extra time than it would when it was just listed in Appendix 3, when all we had to do was the legal acquisition findings. So, and not a very specific answer, but it does vary, and it varies based on workload as well. So just wanted to be just transparent about that, but that's kind of just what we're dealing with.
Okay. Rose, did you want to add to that?
Yes, since Heather raised the non-detriment finding, essentially when we get a completed application from DMA, we have 30 to 45 days to make a non-detriment finding. But one of the reasons that I was excited about this webinar and establishing contacts with individual states is that the more information we can get, and Eleanor will speak to this in her presentation, in advance of getting individual applications, because we're looking at the biological status of the species throughout its range or in particular areas in states. And so, you know, working with you to have some understanding of the management of this species and the status of the species in your state ahead of time will enable us to make non-detriment findings and not have the information on hand before we even get the applications from DMA to make findings. So I wanted to stress that.
Thank you. Okay. I don't see any more questions. So thank you again, Heather, for your presentation and sharing that information. Now maybe Eleanor's up next. I'm not sure, Rose.
Yes.
Yep, I would be next. Thanks, Thomas. So I'm going to talk a little bit about how we make non-detriment findings. Just kind of in general terms, kind of the information that we look for, what would be important for us, and how we get to a final conclusion. So next slide, Thomas. So non-detriment findings are actually defined in the CITES glossary, and Rose talked a little bit about this in her presentation, but a non-detriment finding is a conclusion by a scientific authority that the export of specimens of a particular species will not impact negatively on the survival of that species in the wild. Next slide, Thomas. So when we start to do a non-detriment finding, we look at a lot of information and we gather it from a lot of different places. So we look at basically the type of specimen and the method of collection. We look at the species biology, which includes the life history characteristics. We look at the species range, and this includes both historic and current range, population structure, status and trends, and this would be in the harvested area nationally, and if it pertains to the application internationally, the conservation status, whether the import from the wild will stimulate additional take from wild populations. We look at threats. We look at historic and current species-specific levels and patterns of harvest and mortality, and that's from all sources combined. We look at population monitoring, what exists, what's being done for the species, and we look at management measures currently in place or those that are proposed. And those include harvest practices, and it also includes any adaptive management strategies and consideration of levels of compliance. So for several reasons, not all applications are subjected to the same level of scrutiny. Due to degree of risk involved, some applications are more closely reviewed than others. For example, for biological or conservation reasons, some species have high risk factors and merit greater attention. In addition, we usually look more closely and at native species versus exotic species as well. Next slide, please. So the US has some guiding principles and factors that we consider when we do non-detriment findings. So we looked at the biological and management information demonstrates that the proposed activity represents sustainable use. We also look at whether the removal of the animal or plant from the wild is part of a biologically based sustainable use management plan, and that plan is designed to eliminate overutilization of the species. If no sustainable use management plan exists or has been established, we look at whether the removal of the animal or the plant from the wild would not contribute to the overutilization of the species. And we will consider both domestic and international uses. So what's really important is that we know what management plans are in existence, you know, how these species are being managed, and just get a general sense of that. So those are really important for us in terms of doing these non-detriment findings. It's an important part. Next slide, Thomas. So what we also look at is whether the proposed activity, including the methods used to acquire the specimen, would pose no net harm to the status of the species in the wild. We also look at whether the proposed activity would not lead to the long-term declines that would place the viability of the affected population in question. And also whether the intended export of an Appendix 2 species would cause a risk such that the species would qualify, or there's a risk that the species would qualify for inclusion in Appendix 1. So when we make our findings, what we do, we use a lot of information. I kind of want to stress what Heather and I believe Rose both said, is that the more complete the application is, the better it is and the easier it is to make the non-detriment finding. If we have an incomplete application, it will take longer because we do have to get that information in order to make our finding. And so what we do is we try to consult with states, tribes, other federal agencies, scientists, other experts, and if when appropriate, depending on the species, the range country of the species itself. As part of that, what we also do is we look at all relevant scientific literature concerning the species biology, its life history, distribution and population trends. We look at details of any ecological risk assessments that are conducted, scientific surveys that are conducted at harvest locations and at sites protected from harvest and other impacts. We also look at and try to incorporate relevant knowledge and expertise of local and indigenous communities. And we also look at national and international trade information. And we get a lot of that from the CITES trade database. We take all that information and we try to evaluate the biological impact of the proposed activity. If there's insufficient information, or if there's information or factors that lead to a conservation concern, we're unable to make the required finding of non-detriment. So what we try to do in our non-detriment finding is we take all this information and we summarize it and explain it enough to justify our finding. And a lot of times we're able to find that it's not detrimental to the survival of the species. And in those cases, many times if they're I don't know if it's so much that information is missing, but if there is something that makes our findings stronger or the action stronger, we may put in something which are called permit conditions. And those permit conditions may be the thing that can bring us to a positive finding. And what these generally do is they reinforce our findings. So what it can be is a management plan. For example, with paddlefish, we can talk about harvest season or size restrictions. And so in a lot of our findings, what we do have are these conditions which allow us to get to, the end result of not detriment. The other thing is that we're unable to come to non-detriment because of something that is of concern. But also, if the application or the information that we have is insufficient and we're not able to come to a finding that it's not detrimental just because we don't have the information to be able to get to that point. So it really is critical that, what we do get on our application and in working with you all helps us to make this non-detriment finding. So what we do at the end of this is we make a formal recommendation to the CITES Management Authority for their final decision on the application. And that is basically non-detriment findings in a nutshell.
Thank you, Eleanor. That was excellent. We do have one question from Sarah Schweitzer from North Carolina. She was asking, during these NDF reviews, to what extent are disease-related concerns evaluated?
Deb, I'll take the first shot at that, and then if Eleanor wants to add anything. That's an issue that's, as your Aqua CITES reps know well, zoonosis is now an issue that's being discussed in CITES. There were some decisions taken. But in making non-detriment, again, we're looking at how it impacts the survival of the species in the wild, and so we have. The only time I know where we really have put that in an NDF was related to white sturgeon, which in aquaculture can carry a certain disease that would be threatening to other sturgeon species, particularly in the wild. And so we had export of these captive disease carrying white sturgeons, where we basically made a negative finding because they were going to the Caspian region, where they have natural occurring populations of other sturgeon species. And we felt that it was detrimental, not to the survival just of other of that particular species, but others in the complex. But that's one of the specific times right now. If there was a disease-related concern, I guess I have a question for you, how that affects the survival of that species or some other species it's related to. But this is an issue that everybody's talking about, right? Because some of the issues with some of the farmed animals is that they can carry diseases that could impact wildlife. And so it's something I think that we'll see more guidance from CITES parties in the future, or wildlife disease experts. But currently, it's hard enough to make an NDF related to the survival of the species with the factors that Eleanor elaborated on. And so the sturgeon one is the only one I know where we were able to make a robust science-based finding on that particular facility and carried it out. But Eleanor, is there anything you want to add, or anyone else?
Yeah, I haven't come across anything where we've really factored that in, or it's been an issue with us. So, like you said, I think that it's something that's getting a lot more attention, and, more will come from it.
Thanks. Yeah, I guess from this end, I was thinking that as people consider, and has CITES discusses how risk assessments might be integrated in and other things like that related to disease and reducing the risk of future pandemics. This may come in more, so.
Yeah,
okay.
as a matter of fact, Deb, both DMA and DSA got some money from the American Rescue Plan Act that builds on fisheries and habitat conservation program and the service that is doing the horizon scale of all species imported into the US, looking at what are high risk species. And then once they complete their analysis, we will be looking at, are any of those high risk species listed in CITES and what we might do, if they go forward with proposing some things under the Lacey Act, under the Injurious Wildlife Act. So it's something that's going to get a lot of attention. The good news is we're looking to probably, with that ARP money, hire somebody within DMA, DSA who has expertise on wildlife diseases. So hopefully we'll be better positioned to deal with this, as you said, in the future. But I see Carrie has another question to take and answer it.
Yeah, and we've got, Scott has his hand up, and I just wanted to
Okay.
follow up with that because, AFWA and the states are very involved in discussing One Health. And so I think what you start to get at is we need the wildlife biologists, we need the health officials, typically a lot of times those wildlife biologists and health officials and other folks haven't been in contact as well on these topics. So I think, we're also in contact with State Department, federal agencies like yourselves to talk about how the states integrate into those conversations too, since we're all, and how law enforcement, federal and state get involved. So it's certainly a great question and a complex issue. And I assume the project you're referring to is the one that Smithsonian is working on your
Yes,
behalf? Okay,
exactly.
great. Scott, did you want to unmute and ask a question? You've got your hand raised.
Yeah, sure. Thank you, Deb. It may have been said, but could you emphasize for us that may be new to this? Are the NDFs made at the species level? Are they made at the state level? Are they made at the facility level? Like, in other words, who applies for one, for lack of a better term?
Okay, I will take a first stab and then turn to Eleanor, who oversees making the NDFs. Essentially, it's a combination of both, looking at it throughout its range and at the state, not at a facility level. It's not legal acquisition. We are looking at this, the finding is basically how it affects the species survival in the wild. And for some of the newly listed turtles, for example, the musk turtles, where we know all the exports have been in wild specimens, we are concerned about the biological sustainability for that species, as I believe AFWA supported that proposal. And so basically there, we will probably look at a big picture throughout its range, but then get down to the states, because we recognize that some species, I'm not thinking of a good example right now with turtles, but I know for other species we've had where a species may be basically, listed as threatened in a certain state and have protections. And so if it's wild harvest from that state, we would probably go back to that state. We do this for wolves with Montana, and look at their management plan and determine whether, this export would be detrimental or not. So there, we're probably making an NDF at a state level for those particular specimens rather than the range. But for many of the native species, we try to work at the higher level first and then work our way down. And welcome your thoughts on, as that's why we put out there what the new species are. If you guys got, based on your experiences, have things that you want to flag for us that we should be paying attention to, we'd greatly appreciate it. And Eleanor, anything you want to add?
No, you addressed it perfectly, Rose. Thank you.
Okay. Or anyone else for that matter, but that's basically, I hope that's a satisfactory answer, Scott. I doubt if we would make an NDF on a particular facility unless if we're looking at them as certifying them as under 1016 as captive bred, which would not be the same thing as making an NDF.
I think that's a great response, Rosemary, and I just want to clarify this. I think it will be important, if I understand correctly, for states to hear this. So it is possible for an NDF to be issued for state A, but not for state B. under
Yes,
certain circumstances?
yes,
Okay.
yes,
Yeah.
that is possible, totally possible. And I know we have some examples of that. I know when we looked at diamondback terrapin, I think we might have had some states that are closed, and that's why we ask the questions we do. My take-home message to a lot of these people, and that's where we encountered with the box turtles when we'd go back, some states allow collection, not for commercial purposes, but they allow people to have 2 or 3 of the animals for pets over their lifetime. And that's how they were collected in the state. And then when we go to make a non-detriment finding, we find out that, basically they sold all their pet turtles to someone else who's now commercially breeding them. And so I know we've worked with the states on that and gone back to them. And so in those particular applications, we may have made a negative NDF, so we do it on different levels, but that is how important, Scott, that we need to work with you guys on this and understand how, the regulations vary between state by state, we've learned, and time frame is also important. But when you look at detriment, we go to that point in time. We do that all the time with sport hunted trophies. When that leopard was killed, what was the regulation and the management plan at the time versus, now? And so, if we can, if you guys all designate a point of contact and share this webinar with them, I hope that gives them some assurances. We're not just looking at it range wide. We are able to say yes to some states and no to other states.
Thank you, guys.
Unlike our approved, you're probably thinking of the approved export programs where we have made nationwide findings, but that's a different circumstance. We've got different regulations there and different systems in place. Right now for turtles, I don't think we're there yet that we're going to make a nationwide finding.
No.
Yeah, Rose, we've got some other questions, but since you said that, you may have seen Gordon Batchelor's question in the chat. Yep. Is that something that you would consider working towards? If
we can work with the states, we've been trying to do it for paddlefish, not nationwide, but river basin wide, right, Deb? It takes time, and eventually we will get there, I think. For some of the more, right now I'm hesitant to say that, musk turtle. Let's see what the IUCN assessments, which are, the other ones were older. We'll see the new ones say, but, I think, Gordon, that's the gold standard you want to get to, and we could do it for bobcats and river otters because you guys worked with us to work with Nathan to get surveys done and information. I think that's where we might want to get to with some of the turtle species, but I guess, in my opinion, we're not there now.
Yeah.
Thanks,
unless you can give me the information that shows me we're there now.
Well, we'll continue to have those conversations because I think both, there are some benefits to that, both on both of our capacity sides, right? Between the states and the Fish and Wildlife Service.
Definitely. If we have a nationwide finding, then, basically the applications individual applications don't come to us. But, recognizing that, we need to have a robust record because we have a very litigious, as many of you have encountered, very interested public in turtles and very litigious. So we want to be careful we do this right, and we can stand up to any type of, challenges.
Thank you. I will just emphasize, or I'll just point out that Thomas put something in the chat related to the disease piece on chytrid fungus and salamanders and being an injurious species. So there's certainly over time, in different areas, we've been working with Fish and Wildlife Service on disease issues related to wildlife. So I want to go back to a question from Carrie from Louisiana that says some states' ag departments have authority over turtle farms and are not the state wildlife agencies. In these cases, will contact be made with a wildlife agency to consult on the NDF? And I guess
we work with a lot of times the ag department or whoever we need to get in contact with, if, we just have to find out who the right contacts are, within each state. So we'll work with whomever we need to, who has the information and the expertise to help us out.
It would be helpful if the states that know, say, for example, like in Florida, that their turtle farms are regulated by the ag department. If that's one of the reasons for the webinar, is that if we can work with you, if you can help us identify the states where jurisdiction, we've done this with American ginseng, where either the jurisdiction is shared, where the state regulates wild harvest and the ag regulates farmed animals, or whatever, it would be helpful, since you all know the regulations in your state and how the species is managed. So that's part of the information exchange we hope to establish, that, Deb's asked for point of contacts with each of the states. And so we know in Louisiana that you share some responsibility with your ag department. And we know that's true of Florida, but I have to admit, we don't know that for every state.
You're on mute, Deb.
Yeah, thank you. Yeah, I think that's an important point. And because I do think there are times, even if the ag department is the lead, and the Fish and Wildlife Service is not, or the Wildlife Agency is not, there is still probably benefits to letting the Fish and Wildlife Agency know that these are happening and what the conversations are, since they will have kind of a different take on that. And I see, Brooke, yeah, that there's dual authority in Florida. So those are examples where, they would be reaching out to both of those agencies. Thank you. Rose, is that the wrap?
Yes,
for
I guess that's a
presentation?
good segue. We got about a half hour left, unless people have other questions. What we had hoped was that we could start to use this to establish contacts and have you, and I'll turn to my other Fish and Wildlife colleagues if they want to say anything, but to basically start the level of communications. I mean, how do we get to understand more about the management of these species in your states? And really have appreciated AFWA's help looking for points of contact for us, because that's really important. And, trying to get the information, we've looked at my biologists and DSA, I can say, have looked at your state regulations on your websites, to see what some of your current regulations are for the species that we had added to the CITES appendices. But it would be good to figure out a way that we can just continue to exchange information as we go along this path of implementing these listings. So it's really now just more of a brainstorming, or, people go back and think about it, but anything that you have that you can share with us. I know we talked to Deb about the possibility of us trying to find somebody, trying to see if we can get a fellow or someone to help us update Priya's excellent book that time, the State of the Union for reptiles, because, I'm sure that some of that information needs to be updated. So that's the type of thing, or any information. As soon as we get the draft IUCN assessments, we would share them with you for your input on whether they've looked at everything, or I'm sure they'll be talking to you as they do these analysis, but that's where we are. So that was my hope, Deb, for the remaining time. And I don't know if others want to chime in, Mary, Naima, Eleanor.
Thanks, Rose. Yeah, please feel free to put any other questions in the chat. We have received POCs from almost all the states, Rose, that I will share with you guys, so that there can be that contact as you get permits and as you have questions for states. So we should be pretty good there. I do think, I'm not sure whether it makes sense to provide either my contact or the contacts for the state technical reps to the folks doing the IUCN assessment. So if they have particular questions, we know they can get in touch with the state agency folks. So let me know if you'd like us to kind of help with that, facilitate.
We haven't cut the contract yet. So once we do have the contract, we can, put them in touch, give them I would rather that they be in contact with you and the AFWA reps, and then you can funnel as we always have, you can work with the states to gather the information that they might need.
Yeah, and we can
Maybe the
direct them to the
points
right
of it.
place. We'll just
Right.
kind of see how it goes, but it would probably be good to give them at least a few contacts so
Yeah.
they,
Yeah,
as
exactly.
opposed to trying, not being sure who to reach out. Looks like Mary, you might have something to share.
No, I just wanted to, well, just to say that I think from DMA and the branch of permits particularly perspective, Heather and Maris have been doing an excellent job leading implementation from our office, but did want to let you know that if I'm happy to talk anytime, if you need to reach out. I just wanted to make sure that I wanted to let you know that I'm available too. But I have been depending on them a lot, and they're doing an excellent job.
Great, thank you, Mary. Well, once you guys have that POC spreadsheet, which I can send to you anytime here, we can maybe coordinate. For those on the phone that don't know, the state technical reps and myself will be meeting with Fish and Wildlife staff in DC, some virtually, but hopefully many of you in person to follow up from this webinar and talk about next steps. So, but I think, once you have those POCs, sharing the names and contact information for the different folks that have different roles and responsibilities, if there are any questions from the states, would also be helpful. But also I'm always here, and so are the technical reps for states to reach out to funnel questions. Scott just put another question in the chat. Based on past experience, is there any indication that we can expect to see more illegal trade in new Appendix 2 species given the higher regulatory threshold? If so, is there anything states or U.S. Fish and Wildlife Service can do to prepare? Is there anything we can look out for? And Rose, your hand is up.
Yeah, I guess I'll take the first cut at what is a very complex question. The purpose of an Appendix 2 is not to cause illegal trade, right? It's to regulate the legal trade. And so it is not a ban. And so I would hope that the people who, and as I said, a number of these species were in Appendix 3, so the applicants are used to getting permits, that basically they will comply, that they will continue to apply and will have legal trade in these species. But if there are some states that are closed to any harvest of those species, then yeah, there may be illegal trade, but that may already be going on. And so I'm not sure that, that Appendix 2 listing causes more illegal trade. It's basically how we regulate that trade, but I think law enforcement is well aware of the issues involved in the illegal trade in turtles, and so they'll be looking at this. I would be more concerned that they might switch to the unregulated turtle species, because if you now have to get permits for the 1.8 million musk turtles that we traded in 10 years, and you don't want to do that maybe you're worried you're going to get a negative NDF with those kind of numbers, that you might try to smuggle them out. But I do think that the U.S. takes its illegal turtle trade seriously, and also our combating wildlife branch is focused on the illegal trade in turtles and U.S. native species. So I think that work will continue, and if anything, we're hoping that CITES regulation complements that. I think if things to look out for is to look at people, we've seen this happen with some other species that we put in Appendix 2, that people, particularly if they trade to the EU, that has its own stricter domestic measures, that requires their own import permits. And so the EU, in making their findings to issue their own permits, pays more attention to wild caught specimens. So I guess they'll be looking at wild caught musk turtles and others. But so you might start to see people claim that they are captive bred. And that's something to look out for, and would work closely with the states that regulate captive breeding in some of these species. But I think musk turtles is a good example. To our knowledge, when we canvassed all of this, all the exports were wild and no one was claiming they were captive bred. So that's something I would look out for, is this switch of calling things that were formerly wild harvested now with CITES regulations, calling it captive bred, because many parties, when they see a source code C, would, basically be more favorable to allowing that import. But remember, it's the US who's going to be issuing those export permits and asking those questions. And that's why we're working with you guys to basically look at these so-called captive bred. I mean, to our knowledge, we know that the soft shells are captive bred in the US. We know some of the common snappers and alligator snappers may be captive bred. But some of the other species we're talking about, horned lizards, musk turtles, sternids, we're not well aware that the US previously exported captive bred. So that will be something that we will look at and sends a red flag. I don't know if any others want to chime in and add anything based on their experiences.
Yeah, thanks, Rose. That's helpful. I think Scott raises a great point. Obviously, the intent of any, the CITES listings is to support conservation, but, we know we have examples where, increased regulation has impacts on illegal trade. And as you mentioned, on harvest of other species that didn't used to be harvested so I think it's just something in particular for us all to remember and be aware of, and, do what we can along with our law enforcement colleagues to, ensure that things aren't happening along those lines. And Carrie mentioned here in Louisiana that their agency currently has no authority over turtle farms and very little coordination with state ag. So that's certainly an example of a state where we want, coordination and information to be shared with the state wildlife agencies. So thank you for that, Carrie. And right now, Carrie, your agency put forward Nicole and Larry as a POC, but I'm assuming you'll be intimately involved in that. So that's great. I'm not sure you guys can talk about this with everyone on the call, so we may not want to diverge into this, but we can follow up with Lindsay after. Naima or something, you and I can follow up, but they were mentioning that Texas Parks and Wildlife was notified this morning of the suspension of all commercial trade in specimens of CITES listed species with Mexico. And I think that's obviously of concern, in particular for our border states that do a lot of conservation work with partners in Mexico. So
yeah, I just got a call from while I was in the webinar from Jeb in Louisiana. And so
okay.
I'll give him a call back. I think he's the focal point for the American Alligator Range States for CITES. So I can give him a call back and provide him some information.
Okay, and maybe Lindsay, you can provide your contact information in the chat if you wouldn't mind, so that they can, well, actually I can share it with them, Lindsay. I have it, so I'll send it to you for Lindsay. And after our meeting with state reps and Fish and Wildlife Service next week, if there's a need, I can set up a webinar if we need some sort of more formal communication, in particular with the border states, but we'll just see if that's something we need. Thanks you. Deb. Appreciate that. Rose, did you want to add?
Yeah, I just put it in the chat that
yes.
Standing committee chair, if this evolves into discussion of Tatwaba, to do it with Naima on a separate call, because I'm not to be involved in those US discussions. I don't.
Certainly.
So that I can maintain my fairness and neutrality, because I'll be dealing with this in the standing committee.
Yes, and I think it's probably more about the other species that are impacted from a conservation standpoint by this ban. So I think that's probably where the focus will be, but we'll keep it out of there, away from Tatwaba on this call, certainly. Any other questions or things folks want to share in the chat, or please raise your hand if you'd like to speak. I'm not seeing anything. State state CITES technical folks, anything you want to add before we wrap up? U.S. Fish and Wildlife Service. Carolyn, thumbs up, indeed.
Yeah, I just
Yeah,
want to
I
say
couldn't-
thanks to everyone and look forward to working with you all.
Yeah, I echo that. Thank you for making time for us this afternoon.
Yeah, my thanks as well. I really appreciate this. I think this is the way we go forward in implementing these listings together. It's going to take all of us to do it right.
Carolyn?
Just one quick follow-up question. Do you guys have just a anticipated estimated number of permits you think you're going to be seeing over the course of 12 months with these new Appendix 2 listings? 100, thousands, tens of thousands, just to give the state some idea of what level of burden there may be?
I guess from a DSA point of view, I don't know. I mean, the ones that were Appendix 3, I think DMA will probably still see that number of applications. It's the musk turtles, the horned lizards, the things that weren't in CITES before that we don't know what the volume is going to be like. I mean, I suspect if we continue the musk trade at the level it was, yeah, there's going to be there's going to be quite a number of applications. But when we had diamondback terrapin, the Lemus data showed there wasn't trade. And then we put them in CITES, all of a sudden, oh, look, there was lots of trade in diamondback terrapins. And so we'll just have to see. We've done, we need to do the outreach, but it's hard to predict. Maybe they'll try to sell them domestically. Maybe they'll move to other things. Maybe China's not buying up as many turtles as they did before. We'll just have to see how this all plays out over the next 12 months. Just to give you some reassurances, I've had a vacancy for a DSA biologist, and we will be, Eleanor's been working really diligently with HR to put a vacancy out there for someone, a DSA biologist with expertise in herpetology, like Thomas used to be that person. And so we will be hiring someone. So if you know any good state herpetologists who want to join the feds, we'll definitely share the vacancy announcement with you. But that was my highest priority, would get that expertise, because these new listings, we're prepared to do work and we're trying to prioritize it. As Eleanor said, we'll pay more attention to the native species than some other things, but we are trying to gear up to deal with this in the right way. Naima, is there anything you want to add from DMA's perspective on the workload?
Yeah, I mean, we're in the process of adding 2 CITES policy specialists, as well as various positions within the branch of permits to deal with the permit workload. I can turn it over to Mary also to add some color to it, but we receive about 35,000 permits every year for CITES listed species or things listed under the Endangered Species Act or injurious, and like we have a wonderful team, including 2 folks that you've met today, Amaris and Heather. However, the workload outpaces our human resources in the branch of permits. And so it's a matter of fact. So whatever we can do to create, give you the information to have complete applications and to streamline any processes and get this information out to the major stakeholders makes our review and processing that much more efficient. Mary, do you want to add anything?
I don't have anything in particular to add, except for the appendix, the species, like Rose said, that were Appendix 3. I think we would expect about the same number of those, but those that weren't Appendix 3 are the unknowns. So we really don't know. Amneris or Heather, do you have any more light to shed on that?
I could chime in a bit. I will say that helpful as far as the volume is the master file program that we do. So, you may have one facility applying and then they get, 100 or so permits from that master file, but that review process only really happens that one time until they have to renew again the next year. And we look at the reports from those, 100 permits or whatever they apply for during that year. So the reviewing process is then at least consolidated into that one point. Right. And so then it's looking at more like individual like facilities rather than each permit request. We don't get a lot of single use permits, although we have gotten a few. But at this time, I can only speak to the Appendix 3 facilities that have uplisted Appendix 2 species in them, and that's probably around 50 or so. But again, that may increase now that there are additional species that are listed. So.
Thank you, Heather.
The one thing I would add to all of this, Carol, is that, we don't know the unknowns of the ones that weren't listed in CITES before, but the proposals clearly showed there was trade in the US from this, wild harvested trade in those species. And so we'll see if that continues, then it is an increase in workload, but our administration was committed. I mean, we actually got some directors deferred money. That's what's paying for the IUCN contract, that they know that this would increase workload, but we feel focusing on the turtles is important for the US. We all, US is the second largest, freshwater turtle biodiversity after the Asian region. And so, I mean, all of us, I think the states have gotten petitions from the Center for Biological Diversity, our ES folks have. I mean, I think we all need to pay more attention to turtles, and the ones that we picked are ones that are in trade. So we will do our best to dedicate resources to make this happen so that things are better for the turtle species. I think that's what we all share in common, and not so much, there may be some pain, but if we, we'll basically argue to get more resources when we can. But we have found this administration to be very supportive of giving us resources after this COP compared to, in my experience, some previous COPs we come back to and we haven't gotten resources. We did get some this time around.
Well, it is good to hear that you're able to staff up some of those positions that have that either have been vacant or that are needed for this type of workload. So that's great to hear. I don't see any more questions. A lot of thank yous in the chat. Really appreciate Rose, Naima, Eleanor, Mary, Heather. Who am I missing? I'm trying to see all the names. Rachel and Charlotte, everybody, we really appreciate your time and your willingness to have this webinar. I know we'll talk next week about what we think next steps need to be, and whether we need another webinar for specifics or additional questions or gathering information on how we want to proceed. But thanks so much. We appreciate the partnership and always appreciate when we can, have these conversations and be working together and address whatever issues come our way for the conservation of these species. So, and thank you to the participants for spending this time of 2 hours of your day. I think it's an important conversation, and CITES can be complex if you're not as familiar with it. So I think this was a great overview and a great way to give people some insight into how you guys get to from a listing to a permit. So again, very much appreciated. Thank you all, and hope you have a great rest of your day.
Well,
Thank you, Deb, for
Deb,
putting
for
me on.
inviting us.
Bye-bye.
Have a good afternoon,
Bye,
everyone.
everyone.